So, hello, my name is Marge Lysaght, and today I'm delivering a short introduction to unfair dismissals session. So, it's basically going to deliver a training session on key concepts that are relevant, particularly to people who work within the citizens' information setting, but of course relevant to anyone who deals with employee rights and unfair dismissals. So, I will just share my screen there and we'll get going on the presentation. Apologies about this now. Great. So I'll go back to the start there, sorry. So just to give you a bit of background about myself, I'm an information officer and I've worked with citizens information now for 12 years. I have a background in social policy, but also in employment law. That would be my area of specialty. So I have 12 years experience in delivering information, advice and advocacy to employees and information to employers on their employee rights and entitlements. So unfair dismissals would be something that I'd come across frequently. So this is at the aim of this training session is to deliver an overview or an introduction of what that means, unfair dismissal in the context of employment rights. And today we'll be looking at the main definitions so that the participants can understand the meaning of unfair dismissals, the conditions for actual unfair dismissal cases. What I mean by that is what conditions have to be met to make a complaint that there has been an unfair dismissal for employees, which would be where your complaint would start, who has the burden of proof in these situations, and the obligations of employees and employers in this situation. So obviously this is a virtual training recording. So before the session, I emailed participants and just to get a feel for what your experience and background is on this topic. So I thought it'd be useful to share some of those. Like for instance, some participants have come across, most have experience of dealing with unfair dismissal queries. So some of the types of queries that were shared or cases related to one was when, there was a redundancy situation for an employee who had been there 3 years, but the employer had hired somebody else. So they felt that it wasn't really a redundancy. So that could definitely be an unfair dismissal. There have been cases where employees have just been left on layoff and the employer disappears, but they get no contact. People let go with no warning. People felt that they were dismissed because they were pregnant, because of their age, that they were selected for redundancy, which is when your job no longer exists, but they felt that their selection was unfair. And some employee, one case described an employee who was bullied continuously over a long period of time in work and felt that they had no option but to leave. So all these types of cases you be coming across within the CIS on a daily basis. And it's definitely, we'll be covering lots of relevant information that will help you understand how to deal with these types of queries. So these are the learning objectives for today, basically to understand and identify the unfair dismissals case. We'll just be giving an introduction in this session. We'll later deal with it in further sessions in more detail, obviously. So the definition set out under the Unfair Dismissals Act, as you can see here, from 1977, but has been amended to up to 2015, and that basically dismissal is when an employer terminates your contract of employment with or without notice. That's what dismissal is. And you terminate your contract of employment with or without notice due to the conduct of your employer. So both of those can potentially be unfair dismissals. The second one is known as constructive dismissal. In plain English, that is when you have no option but to leave the employment because of your employer's behaviour. So under certain conditions, then in these circumstances, an employee can and may bring a claim for unfair dismissal against their employer. The employer then has the burden of proof to show that the dismissal was actually fair normally. So there are reasons that you can be fairly dismissed. All dismissals aren't unfair. So these fair dismissals are set out in the Act. Capability is one, and that is that you're no longer capable of doing your employment. Competence, you're no longer competent. Your performance often would be examined here. Qualifications, sometimes this can happen, and that qualification requirements change for a job. And you would think it would be unusual, but a case that recently occurred in the childcare industry where there was actual guidelines brought in where all childcare providers had to have a certain qualification. So this is where it could result in a fair dismissal if an employee didn't meet the standard. So one obvious one that would often come up is that there'd be conduct or gross misconduct issues. So an employee would be dismissed for conduct, and redundancy would be another one. Redundancy, by definition, and we'll be dealing with this more in the main course, is when your job no longer exists. So sometimes, that would obviously, when your job isn't there, it's not there. Or contravening the law. It could be illegal to keep you employed. For example, you can't employ somebody under 14, for example, and that would be against the law, things like that. The law can change as well, which can then result in dismissals on occasion. So automatic unfair dismissal is outlined under the Act. So if you're dismissed for any of the following reasons, it's considered to be automatically unfair. So that's trade union membership, religious or political opinions, legal proceedings against the employer. So that would be a case where you might be a witness against the employer in some kind of other employment case that they have, or that you're taking a separate case against them. It could be when somebody injured themselves at work, they have a personal injury case against the employer, and they can't be dismissed because of that. Discrimination, we kind of understand the definition of discrimination in legislation is that you're unfairly treated because of something like race, colour, sexual orientation, age, membership of the travelling community, pregnancy, or anything related to maternity issues. Also, automatically unfair is if you're fired because you're availing of your protective leave rights. That would be things like maternity leave, carers leave, paternity leave, anything that's protected leave, where you can take time off from your job for a particular reason and return to the same job. That's basically what it is in layman terms. Unfair selection for redundancy. So we discussed what redundancy means. So often you'd have one job that is gone, but you'd have 10 relevant employees and you have to pick one to say you're the person gone. So there has to be fair process in how the person is picked. So unfair dismissals claims can happen when this fair process doesn't happen for the person and they're picked unfairly. So this is translating it into understandable, I suppose, layman terms. Making protected disclosure is also automatically an unfair dismissal, and that would be where somebody reports a wrongdoing and they're dismissed specifically because of that reporting. So that could be something like if there was a serious health and safety issue in the workplace, like there were, loose live wires, and someone reported it as potentially a death trap, and they made that report and then they're dismissed because of it. Or if there was any kind of issues with accounting and they were reported, or unlawful revenue activity, or anything that's unlawful and that's reported and you're fired because of it. Whistleblowing would be another term used for it. So there are certain conditions that have to be met to be able to make an unfair dismissals complaint. So to be able to complain that you're unfairly dismissed, you have to be an employee. That sounds very obvious, but sometimes it's not. So sometimes people would have a contract of and for a service. If it's for a service, you're delivering a service and you're contracted for it. So you're actually self-employed. So if you're a self-employed person, that's your business. You have a contract to deliver a service and the employer has no obligations to you. They may pay you annual leave, or they may do certain things that reflect the employer-employee relationship, but that's not necessarily the case. So you have to be over 18 years of age, over 16 years of age and not of retirement age. You have to also be working for the employer for more than 12 months, which is a really key thing to remember when you're helping people or talking to people of unfair dismissal. Often you'll have someone who's dismissed after 3 months with no notice or no reason, but they can't take a case because they're not there for more than a year. Less than 12 months is allowable, but it has to be because of one of the automatic reasons we just talked about, or because there is discrimination, which is one of those as well. There's a really key thing to remember. When there's a 6-month time frame for employees to make complaints to the workplace relations, the body that deal with unfair dismissal claims. And if they go beyond that 6 months, it can be very difficult to make that complaint. So it's 6 months from the date the dismissal happens, okay? And if the person is dismissed and they get payment in lieu of notice, that date happens when the notice ends, okay? 6 months is a key thing to remember when you're talking to somebody about when they were dismissed. And it can be extended up to 12 months, but you have to demonstrate that there was reasonable cause for the delay. So this would be like unfair treatment, like it can be that somebody has kind of learning difficulties, or they were going through a really stressful time, they have doctor's letters to prove it, or whatever, or that the employer acted in some way to prevent them from making that complaint. If you have less than 1 year service, your employer, you can still make a complaint about it, but not under that act. So we'll move on now. You have been conditions for making the complaint. You have to be dismissed. You can't make a complaint if you haven't been dismissed. And then there's a thing called constructive dismissal, where you resign, but it's because of your employer's contract. If your employer disputes that a dismissal actually took place, you have to prove that it did. So this be cases where people are left like on long-term layoff and they make an unfair dismissal claim, but they've never been dismissed. That could be one example. Burden of proof, and the person who is the employer always has the burden of proof. They have to justify the dismissal, show there are fair grounds. The only case where the employer doesn't have to prove it was fair is in the case of when the employee is constructively dismissed and they decide to leave the employment because of the employer's contract. They have to prove it in that situation, the employee. Employer's obligation is to show the dismissal, employees rather, to show the dismissal complaint took place, complete the WRC complaint form on time, get the right legal name of the employer, and use any appeals process that's available to them. They also have to mitigate their loss. So they have to show that they weren't just sitting around waiting for a case, that they were trying to resolve the loss or find another job. Employers' obligations to justify the dismissal under one of the fair grounds, and we have gone through them, and they also have to show they followed fair procedures. So we look at all that later on in the course in more detail. This is just a basic introduction. So the different types of unfair dismissal complaints that can arise would be that there was lack of fair procedure, discrimination, redundancy, or it was an unfair ground that maybe they said it was redundancy, but there was no redundancy. So thanks a million for listening. We will have an online drop-in session for questions and answer later this evening. That'll be scheduled. You can also email me questions. We'll also set up a forum for the rest of the course where we can discuss any questions that people have, or you can contact me directly. Also, just for yourselves to review the learnings basically out of this session, I have a pop quiz here. All the answers will be in the presentation. We have discussed them in brief today. And if you have difficulty answering anything, there's no problem. We can discuss it in our online question and answer drop-in session later, and you can email me. For all the rest of the course, when we start, we'll all be participating within the training session. So we'll have questions and answer and review sessions there. And I hope that everything today was clear, and anybody with any questions, just get back to me. There's no problem. For your own references, here are all sources of reliable information on this topic. that you can access in your own time, and we'll be dealing with all these sources in more detail throughout the 6-week course that you'll all be attending. Okay, so thank you very, very much for your attention, and I hope to see you all soon, and that we'll have an enjoyable course. All the best.